And coming our way next is Business and Immigration Law Updates. This will be hosted by attorney Ramesh Khurana. He's the chief attorney and counselor at law at the Khurana law firm located in Gaithersburg, Maryland. On screen with him today is no stranger to GTV, the famous attorney Mr. Kenneth Haber from Boyd's, Maryland. What's their topic today? Let's find out together.
Welcome. My name's Kenneth Haber. I'm a former assistant United States attorney, and I'm former senior attorney of the Office of Inspector General of the United States Department of Health and Human Services. With me today I have a very renowned attorney, Ramesh Khurana. Ramesh is renowned because of the fact that he has clients all over the world. Literally, he's an immigration attorney, and he has clients across the country. He's helped many people over the years get themselves situated in this country in a fashion that they want to be, either as a citizen or working, and he's helped people just on countless number of cases. And this is the Capital Forum. Welcome, Ramesh.
Thank you, Ken. Thank you for a very nice introduction. I appreciate it.
Well, we appreciate you.
Yeah, thank you.
We're going to be talking a little bit today about PERM audits. Could you please explain to the viewing audience what a PERM audit is?
Yeah, sure.
What a PERM application is?
Yeah, sure, Ken. The term PERM stands for Program Electronic Review Management. This is a program which was introduced by the U.S. Department of Labor in 2005, now quite old. Under this program, whenever you have to start the green card process for any employee, so that means this is based for the employment related green card, then you start the green card process by filing the PERM application. So now once the application is filed, it is processed by the U.S. Department of Labor. When you are asking me a question about PERM audit, now they can look at the application and they think that audit is required. What does it mean? That means the filing of the PERM application is online. This is based on just attestations made by the attorney, if attorney has been hired by the employer on behalf of the employer, that this is the information to support the application. Now they want to see how the backup papers have been recorded and how these have been preserved. So they would like to see those documents. So that is part of the audit process. So we will receive a letter from the U.S. Department of Labor. We don't like to receive that. We don't feel happy whenever the PERM application is audited, but we have to deal with the situation. So we have 30 days to respond to the audit and provide all the documentation requested under that audit letter, and there may be certain special concerns or reasons, then you have to give an explanation about those reasons as well. So you file your response in 30 days, then you are in the audit queue. It takes a while, sometimes even up to 1 year before they come back with their decision. Either they certify the labor condition application or they deny it. So that is the result of the PERM audit.
I would imagine that before even making the application, a good attorney such as yourself has all the paperwork already available and ready for that audit. So 30 days is no doubt normally an adequate amount of time.
I agree with you. In fact, this is the requirement that whatever documents you are providing to the U.S. Department of Labor in response to the audit request, these documents were existing at the time of filing of the application. As I said, this is an online attestation certifying to the fact that these documents exist, and you just cannot create any document after that. So you are right, 30 days are adequate for the purpose of filing a response. All the documents are in record. So you are just preparing a list of the documents and also answering some additional questions which the Department of Labor is asking.
I take it that they don't, when you're filing your certification, they don't ask for the documents in a digital format at that time then?
No, these are not asked in the digital format at that point of time. That's true.
I see.
Yeah, in fact, that's the way this program has been structured.
What happens when you file a PERM application? You have to declare that there's that the beneficiary has a familial relationship with the owners of the company.
Ken, it becomes a very tricky situation when you answer a question asked about the familial relationship and you say yes. Let me give you a practical example. Let's say that ownership of the company is with the father and the son is working with that company on H-1B. And now this company is filing a PERM application so that green card process is started for the son. And then you truthfully disclose that there is a familiar relationship, but no additional details are provided here, just you say yes. Now, Department of Labor doesn't know what are the details when you said yes. So, there are 99% chances that this type of application will be selected for an audit. It's not necessary that it would be, but it will be selected for an audit. They would like to know what's the relationship. When this kind of situation happens, because Department of Labor would like to see that integrity of the system that is fully complied with. Now, what is the recruitment process? Like who's doing the recruitment? What is the size of the company? Let us say if there are 500 employees, probably things could be considered at distance, like some HR department is conducting that recruitment, probably it will be a different kind of stuff. But let's say there are only 10 employees. So, what conclusion you would draw? You will definitely say that probably the son has an influence on the company's decision making process. And this application is based on the fact that maybe you rejected some other US citizens and green card holders who applied for the job opening, and whether those rejections were based on merit or not, or because of familiar relationship, they just eliminated those additional applicants. And likewise, maybe a person has some ownership interest in the company. In fact, I have handled several situations. Sometimes certain employers give certain percentages in the businesses to their employees, like 1% or 2%, just as an incentive, like stock options, right? Now, in those kinds of situations, you can very well explain when you are asked in the audit that this is just 1% of the stock holding, and this is part of the stock option, this is part of the staff incentive which is given to most of the employees. You can give a list of percentages which are owned by 10, 15, 20 other employees. It has never been any problem. And these kinds of certification requests have been certified.
If in fact the employee is relative of the owners, and in fact if they've rejected other people, but for documented legitimate reasons that they couldn't do the job, that they didn't have the same skill qualifications, I would imagine there would be a very careful analysis of that, but would that wouldn't preclude somebody from getting that job, would it?
You know, the standard of adjudication will be increased. That will be very high, because the presumption here is, like I gave the example, like it's a father-owned company and that company is making a decision to hire his son and rejecting other US able and willing. When I say able, that means maybe they are equally qualified employees. So, of course, they would ask for the resumes and they would look at the reasons for rejections, and then who made the decision. Like if there is an independent HR person, and so under totality of the circumstances on a case by case basis, I think it will be the judgment of the certifying officer. to make a decision.
What's the denial of a PERM application due to government or department error? What's the nature of that?
Okay, denial of the PERM application due to government error. It's happening a lot. You know, let us say that you filed certain documents as a result of the audit, and the certifying officer is not able to locate certain documents. You said that you advertised in the Washington Post and enclosed the tear sheets of the Washington Post newspapers, but the officer says, I didn't find them, you never provided to me. And likewise, there is some specific regulatory language of the notice of job posting. You put the job notice posting and they say that we do not find this paragraph. Maybe it was included in the second page of the job posting notice. So they will just deny, they will give you the reasons. At that point of time, you look at your record, there are no digital record provided to the Department of Labor. You have the same set of documents which you have provided to the Department of Labor as a result of the audit, and if you see that those documents were existing at the time of filing of the application and you provided those copies to the US Department of Labor, then you look at them and respond to it. When you are talking about government error, the reason is if you can prove to the satisfaction of the certifying officer that this denial is due to government error, there is a special government error queue. What does it mean? That means you do not have to wait in the busiest and lengthy queue which takes about a year at this point of time to make a decision. Under the government error, usually the answer comes back in 30 to 45 days. So, in 30 to 45 days, the officer would certify your labor. If those documents are existing, he is able to locate. And if he is not able to locate those documents, then it will be taken out of the government queue and transferred to the general queue. But we will not hear anything about that. If you do not hear in 45 days or 60 days, depending upon what is the processing time going on, then you should think that it has gone to the general queue. Then you have to make a decision depending upon the situation of the employee, whether you want to continue, because it is staying in the general queue for about a year.
That's a long time to wait.
Long time. Yeah.
What happens if the Department of Labor refuses to accept that the denial was caused by a government error?
Yeah. As I said in response to the previous question, I covered little bit part. If it is not accepted by the certifying officer that there was government error, then he is not going to accept under this quickest possible queue and respond to it in 30 to 45 days, and the case will just be transferred to the general queue.
So it just get processed in the general
queue
and you'd end up before administrative law judge?
No, here there is no administrative law judge at this point. So basically it's transferred to the general queue, and at that point of time wait is for about a year for the decision. So you have to wait.
Nice.
Yep.
I'd like to thank you very much. I'm sure that this has been most informative for our viewing audience, and again, I'd like to thank you for joining us in the Capitol Forum.
Ken, it's always a great pleasure coming to these studios and answering your questions. Thank you so much.